listed on there.
Oh, okay.
Okay.
All right. That's what caught me off guard there. I just was wondering.
Yeah.
All right,
Okay.
it's 7 o'clock, call the meeting to order, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America,
States of America.
and to the republic
For which it stands,
one
nation,
nation, under God, indivisible, with liberty and justice for all.
justice for all.
All right, first thing, any public discussion on any agenda items? I'll make a motion, we approve the minutes of the October 23rd, 2024 Supervisors meeting and the November 13th budget meeting.
Second?
Motion's been made and second. Any questions? All in favor signify by saying aye.
Aye.
Opposed, no. Motion carries. And by the way, Supervisor Nimble is out of town and
Unreachable.
unreachable, yeah. I'll make a motion to authorize and ratify the payment of bills and payroll for the month of November 2024.
Second?
Motion's been made and second. Any questions? All in favor signify by saying aye. Aye.
Aye.
Opposed, no. Motion carries.
I'll make the motion to approve the departmental reports.
I'll second it. Motion's been made and second. Any questions? All in favor signify by saying aye. Aye.
Aye.
Opposed, no. Motion carries.
If I could just add something to item 6, that is within Washington Financial Bank, that we're just moving it from a money market to a public funds because it earns quite a bit more interest.
Good job.
I'll make a motion to authorize the township manager to move the uncompensated absence fund checking from a money market to a public funds checking earning 4.75% interest at Washington Financial Bank.
Second the motion.
Motion's been made and second. Any questions? All in favor signify by saying aye.
Aye.
Opposed, no. Motion carries.
I'll make the motion to advertise the proposed 2025 budget to be adopted at the December 18th, 24 Board of Supervisors meeting.
I've got a question. Is it proposed budget or is it the preliminary budget?
I would say, well,
I would say it's preliminary.
preliminary, yes, because we have to make that one change.
Right.
Okay, I'll change that to preliminary.
Is that all right with you, Shane?
Yeah, amend it to say preliminary proposed budget.
Okay, preliminary.
I'll second that. Motion's been made and second. Any questions? All in favor signify by saying aye. Aye. Opposed, no. Motion carries. The only other, we have a correspondence, the Act 223/13 notice from Range Resources concerning the DB Carnes site have been received.
Yes.
They're in the township office. I'm going to do something else here. Matt, I want to present a plaque to Mount Pleasant Township Police Department at 108 Main Street. This renovated police station was dedicated to our police officers and community in June of 2023. The station was dedicated to help ensure our police department was able to continue providing professional law enforcement services to our community by providing an improved location and facility. Congratulations.
Yeah, thanks guys. Appreciate it. We'll hang in the lobby for everybody to see, the community, the visitors. So, appreciate it.
Yeah, nice job on that, for sure.
And Matt has one more thing he wants. You had one thing you wanted to bring up, Matt?
Yes. So, I'm going to sit down unless you guys want me to stand. So I have, we've been talking about the sergeant position for some time now. I do have a test finalized, ready to go. I'd be happy to send it. What I would like to do is at least get approval to administer the test and then give you guys the results after. So I was hoping in December, at the December meeting, pending everything completed, we could promote somebody in December at the December meeting.
And we've already budgeted for that, right?
Yes.
Yeah, we had some things pop up. We agreed to hold off. I'm ready to go as long as the board gives me the blessing. I'll have the test administered.
Since it's already budgeted, I don't see a problem. I would go ahead and do your testing and see what you come up with.
I'll share the results with the board. Yes.
You okay with that,
All right.
Shane?
Yeah, that's fine there, yes, and I think the reason we wanted to wait is because we had to do what we did earlier with the police hiring.
Yeah, which was fine. It worked out. I think we're ready to go now. I'm ready to go. So the delay was definitely not an issue.
Okay, now
All right, I'm okay with that.
our meeting is earlier in December, so it would
Yes,
be.
I think it's December 18th, I believe.
Yeah,
It is. I'll
Yeah.
have 3 people do the panel, and then as long as I get a date from them that works between now and then, that's it. That's all we have to do. We'll have
Okay.
2 candidates eligible.
All right. Move on to public comments. Please state your name, your address, and please hold your comments to 3 minutes.
All right. Wayne Roth, 184 Southview Road, McDonald, PA. All I want to accomplish tonight is have a meeting with the zoning officer, Harold Ivy. Please set up a time. I only have 3 minutes to get this done on this meeting here, and if you could set it up, I'd really appreciate it. Is
In
there any
regards
chance-
to,
House in my backyard.
Mr. Chair, would you like me to
I would like you
comment
to.
on it? Mr. Roth, as you know, the court, you have a pending law.
You don't have to worry about my
Sir,
court.
if I might be allowed to talk, and then you may. In 2021, the code officer, zoning officer issued a decision that you didn't agree with. As was explained to you numerous times, and you had your own attorney as well, you did not appeal that decision. In 2023, you filed a private nuisance lawsuit against your neighbors in the Court of Common Pleas of Washington County. On or about on October 11, 2024, the court issued an order dismissing that case with prejudice. To my knowledge, the 30 days having passed, I do not believe you filed any appeal to that matter. In the meantime, as you recall, I met with you and your wife and your son on approximately July holiday 2023 at length up on the bench outside the police station. Tried to politely explain the township's position on that and the restraints. Also suggested again that you get an attorney and use an attorney. Mr. Nimmel and I also met with you in August of 2024 while the summary judgment motion was pending. Again, urged you to get an attorney in your case. And offered that if that attorney contacted us or the court contacted us, we would be happy to participate in any kind of mediation that was requested of us of the parties. The court did issue a decision on October 11th that found, and the decision adopted the findings of the defendants that you sued, and the court adopted the findings that found, among other things, that Washington County Conservation District and DEP also responded to complaints and were found without merit. The zoning officer, as I mentioned, made a determination in 2021 it was not appealed, that the plaintiff, Roths, have established no causal nexus between any action of the defendants, their neighbors, and any alleged harm to them. No expert report or conclusions that any contamination alleged by plaintiffs originated on defendants' property or because of any action of defendants. Moreover, there was no evidence of record to support their claims, no evidence that defendants' conduct was a legal basis of any harm, no evidence that there was any bacteria in your property. It came from the defendant's property, and no evidence that they have sustained any harm, and they can't produce, they did not produce, you did not produce in that case. And accordingly, that case was dismissed. The appeal period, to my knowledge, has passed. No appeal has been defined. I have advised that our code officer, our zoning officer is not going to meet with you to receive or process a complaint based on that same conduct and cannot enforce that same conduct. It's what the courts would call stare decisis. It's been decided. It's been not appealed. It is the finding that it cannot be reversed either by this board or by a new code officer or by a zoning board. And for that reason, yes, I have advised that our code officer does not need to meet with you to receive a complaint, nor should he or can he legally process or issue an enforcement action based on these same facts. And that's where you're restrained.
Okay, who told me to get rid of my lawyer and you would talk with me?
Absolutely, that's false, sir.
You're
That
full
is
of
absolutely
shit.
false. That is false. We told you actually the opposite. Actually, what I said to you is under my legal obligations, under the ethics rules that attorneys follow, and we discussed this with Mr. Nimmel and you again, when you first alleged that against me. What I explained to you originally was that because you're represented by an attorney, I am not allowed to speak with you without the attorney sending me a written communication saying, Tom, you're allowed to speak with my client. Now, you decided that when I told you I can't speak with you since you're represented without your attorney, that your decision was, I'll fire my attorney. That was your decision. That was not in any manner, shape, or form the advice or suggestion that we were making to you. I was following my ethical obligation and actually many times said I would be more than happy to speak with you and your attorney, and I would speak with you without your attorney when you were retained if I received a written communication as I am required under the ethics rules that I have to follow before I could speak with you in your attorney's absence. I never, ever told you, suggested that you fire your attorney. In fact, Mr. Nimmel and I urged you to please get an attorney as late as August 26, 2024.
Will you shut up for a second?
Sure.
Okay. I have a well that's contaminated with E. coli and chloroform. And you don't have any, I'd like to have that with the zoning officer.
Again, as I've advised, our zoning officer is not going to meet with you to receive complaints about this matter, and that's all I'm really going to say about it this time, sir.
How about all the paperwork in the E Code 360? You don't just throw that in the trash?
Again, I've said what I've said, and
Yeah.
you've said your piece.
You dazzle them with your bullshit. Yeah. Your brilliance and it's pissed me off. Now, the E Code 360, you don't have to follow that at all?
Again, I'm really not going to comment further on that.
Yeah, why not?
Because
You'll
I
get
don't
in
wish
trouble,
to.
that's why.
No, it's because I've explained it ad nauseum and it's not to any productive end, sir. Might have been helpful if you submitted some of this evidence to the court in the case that you had, because the court actually found that you submitted nothing to the claims.
What about that?
Again, I'm really not going to comment on. You can't really get your case here.
What about
You're
that?
happy to make your comments.
What about this raw sewage right next to my house? What about you calling the police on me? This is that pen right here. You got it?
I did.
Yep.
I'm sorry that there's.
Yeah, dazzle me with your brilliance and baffle me with your bullshit. That's what it is.
I'm sorry to feel that way.
Anything to say, or is-
Yeah, I'm just here to support my folks. Their health, well-being, and safety is the utmost importance to me. I don't know, this is a severe water quality problem. This is created, and you have the authority to remedy this problem. I mean, think of your mother and father. How would you I don't think it's any way to treat someone that's been here taxpayer for 55 years. And think about the 2 years non-conforming use before there was llamas. 2 years of non-conformance, the lady got divorced, there's no animals in that pen. The Witherers got here, suddenly there's cows. You go against just about every code in there.
All matters that you could have appealed 3 years ago and did not, and all matters you could have brought before the court and did not. We're constrained.
Well, I understand it's not a sympathetic audience, but it's definitely, I think it's your duty to protect the residents of this township.
The zoning officer acted in good faith and followed the law. You did not appeal that. Again, you've
Yeah, but who's on
exercised
the
your rights,
appeal board?
the board,
His son?
and myself, and the code officer, and the zoning officer, and I'm sure the court of common pleas acted in good faith in attempting to the best of their ability make the determinations they made in this case.
Well, I just don't know what kind of people would hurt other people and not do something about it. And that's just not something I would do or how I was raised. It's a damn shame. It really, truly is. That's all I have to say.
Anybody else have any comments?
I just wanted to add, but this isn't related to that.
I can't hear that
But
comment.
that
No.
wasn't related. I wanted to say something.
Oh, okay, go ahead. They're
My name's
done.
Mary Jo Stazzle. I live at 46 Woodland Road in Hickory, and I just wanted to know if there was anything new with Mr. Andreas' situation. I know he appealed. It's supposed to go before the hearing board, the zoning hearing board, and we will get letters on that. So,
As far as I know,
Yes, and as I indicated to you, and when we last communicated, Mrs. Stazzle, an appeal was filed. Also, as I explained to you, the property owner does have an ability to file an application to lawfully, under a conditional use approval and a land development approval process, obtain approval to lawfully conduct a business, contractor's business on that location. As is commonly done in enforcement actions, I am speaking with the property owner and his attorney, and am discussing with them their proposal to submit an application to the board, to the township for a conditional use approval and a site plan. If they agree to do that, we will allow them some time, as that is commonly done, to do that. In the meantime, they will maintain no operations, active operations other than storage and minimal operations in the meantime, no business operations in the meantime. If they agree to file an application in a timely manner, we will enter into an agreement to stay their zoning hearing board appeal hearing. And then if there is an application filed, all of the parties, you certainly and the other neighbors, will get notice of any conditional use applications. They would have to go before the planning commission, then before the board. There would actually have to be a public hearing on their application. But as I think I explained to you previously, our zoning ordinance does allow in that zoning district 1 to operate a contractor's yard if they go through the process. So the person is in violation right now, but with all enforcement matters, townships do work with folks who are non-compliant to bring them into compliance, and that's the discussion that's ongoing right now.
But I do know this much, the Water Conservation District, they said that he is not compliant with anything they want. They said they sent notices to the township already, and they were gonna make phone calls too. They're turning it back over to the DEP because he's not doing anything that he's supposed to do, doesn't have the permits or anything that he's supposed to have. And what's lawful is often, might be lawful in your eyes, but often as in this case of this man, this isn't right.
Again, with regard to the DEP notices, those were received by us. We're in communication with the DEP. They asked for an update regarding the matter, which we've shared with them exactly what I just shared with you. Obviously, they're aware that the building was constructed since the time of their last inspection. They will be following up on that. If there is a land development application filed, approval of the module and all that sort of thing will have to be part of that. Obviously, if they are unable to achieve that, they will not ultimately be able to get their final approval to do what they are doing. But they will have an opportunity to bring themselves into compliance with regard to those matters and with regard to the use of the property.
The same thing go true for the conservation district?
The conservation district, yes. I mean, they're the ones that will have to vet and approve
All right.
their plan, just like with any other plan. We have that other subdivision where they're seeking the
Yeah.
approval for the sewage separately. That's like a third-party approval.
Okay.
They do have to submit that to them, and they will have to gain approval for that. I understand they're in the process of hiring engineers to assist them in the land development plan and in the DEP matter. But we've been keeping and will continue to keep the conservation district folks apprised.
So if they do apply, you guys would be notified along with everybody else
Yeah,
on the road
for the hearing,
for a hearing.
yes.
Yeah, and they will have to as part of
Eventually,
the.
we're gonna go to one hearing. Are you talking about then after that another hearing?
They have filed an appeal. The zoning officer issued a notice of violation. They appealed that, okay? Claiming, anybody can file an appeal, a timely appeal to the zoning board if they think the zoning officer was wrong. Okay, they did file that appeal. However, as I stated, the appeal would be moot if they agreed to lawfully come into compliance. So what is often commonly done is they'll file the appeal to protect their rights. They have a right to do that. And then we can enter into an agreement with them that we will stay that zoning appeal, the zoning hearing board appeal, on the violation notices while we allow them a reasonable opportunity to file an application with the planning commission and come before the board to get approval for the use itself. If that makes sense.
Yeah, I got it.
And we will, we will keep you apprised of everything as it's going.
Because this man's had this intent from the beginning that the township kept telling me no. Individual pole barn, private belongings are gonna be stored there. That was it. And not according to him. I only met the man twice. February 23rd when he told me his plan. And I immediately notified the office. And then when he called the police on me and I called the police on him when he was moving the trucks in and out. And it's a sad situation.
We'll keep you informed if it goes to a hearing, so. At this
Either
point,
And
way.
your whole life to build your little house. And then some guy can come along because I don't know why and take over and get exactly what he wants, because this is exactly what he was saying in February of 2024. And he's going to work it out so he gets what he wants. And every neighbor on that road, hopefully they will all be able to come. Some of them work evening shifts, but I'm hoping they get to the zoning meeting.
Ma'am, and I have to tell you, and I appreciate I appreciate that, but the zoning rules are not new.
That came from 2018, if I'm not mistaken.
No, we have long allowed in the A1 zoning district a contractor's yard as a conditional use. Even if the gentleman had not built a building yet. Again, when folks are out of compliance, where the townships aren't generally into retribution, they're into bringing people into compliance. And if he had never built that building and he had showed up at the window and filed an application for a conditional use to put that business in there and build that building, if he meets all the requirements, the engineering requirements, the buffering, or whatever requirements there may be, the board would be legally compelled. They would not be allowed. It's not a popularity contest. Even if 10 people came in and said, we don't want this near our houses, it's the application, we have to follow the law on what's allowed in that district. And they are allowed, as a conditional use, to have a contractor's yard on that property. You may have not been aware of that, but that's been the case.
I became aware of it.
And in fact, one could actually put a salvage yard in the A district as well. There are many uses that are, they call it an agricultural district, it's more of a rural economic district. There are many uses that are non-residential that are allowed in the A zone.
A1.
The Sam Goldfarb subdivision, though, does have those rules and regulations. I no longer am an attorney because when you did what you did, and I thought we were finally finished with Mr. Andres, I paid my bill to him, and I said, well, and he said, call me if you need me, but I thought we were finally through with this. Those regulations are at the courthouse. I asked if anybody wanted those. All three supervisors, I said, do you want copies of these which say what these subdivision lots were supposed to be used for? Because Sam, I told you before, Sam said if you take these to the courts, you will win. So I'm just saying, when I asked the supervisors to please read these, I was referred to Tom, who responded. And
Well, that's where it's really got to go at this point.
And I'm happy to look at any of those papers you have, man, but also, as I explain in public, whether it's like a homeowners association and maybe has rules on stuff that folks aren't allowed to do, you know, no swimming pools, no certain things in that community, say Cherry Valley Estates has some kind of private rules, or say you have things of that nature. As zoning officer of the board, even if you brought those to the government is not allowed to enforce those. We have to approve or disapprove based on what our zoning allows. If you have private covenants and you wish to enforce those, the government doesn't enforce those. You have to get an attorney and you have to enforce those against your neighbor if you believe. Now, to my knowledge, my understanding is that there are no restrictive covenants either on the plan documents and the plan of lots that we live in or otherwise. I only have heard that anecdotally. I do not know that for a fact. I'm happy to look at, but I can't, nor can the board, act on private covenants. You can if they exist, but this board can't. And in fact, we would not be allowed to deny the conditional use based on the private covenants. You would have to seek enforcement of that under your private rights.
Do you have a copy of those?
I didn't bring one with me. I was going to bring them up and get copies for you three guys, and then that was basically.
I would suggest you bring it up.
I'll make a copy.
And
and
she'll
send
make
it.
My understanding is, yeah, I beg your pardon.
And
Everybody signed the deed, and the only thing written in the actual deed is there were restrictions on this land. And go to book such and such at the courthouse to see these restrictions. That's the only thing that's written in the deed. But when you go to that book at the courthouse, that's where you'll find them all. So I will bring them up for you.
And more importantly, if you should share those with Mr. Andrus. I'm happy if you transmit them. If you transmit them, and my understanding is, and again, I'm not his attorney, and it's not I'm not into the private side of it. It's been reported to me that there is nothing in Mr. Andrus' deed that alludes to any restrictions. I have not seen his deed. Again, I haven't seen your deed. I haven't seen any covenants because, once again, we can't act on covenants. We can only act on the ordinances. You can act on covenants if they exist.
But I'm waiting for this to be resolved.
Well,
bring them up.
If there's a covenant, if you believe that there's a covenant that prevents this entire exercise from happening, then the sooner you get it to Mr. Andrus, I'm not sure. I'm not sure why it would be helpful to your cause or position to wait, and then if it gets approved, then bring out the covenants. If I were you, I would bring that matter to a head as soon as possible.
Yeah, bring them up. She can make a copy. She can scan them and send them.
And I will certainly be I will be happy as a courtesy to transmit them to the attorney for the
There you go.
Property owner to do with as he determines and interact with you as they determine on the covenant matter.
Okay.
I'll have
All right. Anybody else?
Can I speak again? The E-Code 360, all those rules and regulations are on the website. You go through there. You don't follow any of that stuff, right?
We follow it on, and we follow the law and the case law.
You cannot follow the law if you don't read it. I bet you 90% of you guys don't know shit about that E-Code 360. Okay. Right there's the guy that started it.
What did I do?
You went to George and told him what to do. Yeah, that looked like
Can you
that.
prove that?
No, I can't, but you were
There you
here.
go.
when
So
happened.
so therefore you're making assumptions. I'm not gonna get in an argument with you, just take note. Thank you. Anybody else? I make a motion, we adjourn?
I second that motion.
Motion's been made and second. Any questions? All in favor signify by saying aye.